If I can call this meeting to order, do you want to take off the executive session things that are? Oh, yes.
This is governance now, right? Yes.
Yes. You're all invited to a meeting of the MTA Governance Committee. Good afternoon. Can I ask for approval of the minutes, please? Do I have a second? Thank you. Review updating of MTA bylaws, Mr. General Counsel to my left.
Yes. You will recall that in December, the board approved revised bylaws for the MTA as a whole. At that time, we indicated that the agency bylaws, meaning the subsidiaries and the affiliate bylaws, would be reviewed to incorporate the same adjustments based upon statutory changes that had been made in governance in 2009, principally the May legislation that adopted the chairman, CEO position, et cetera. So what we've done is we've gone through the agency bylaws, which in some cases have not been updated for decades, and have revised them so that as a whole they're all harmonious. As you know, when we meet as a board, we meet simultaneously as many boards, so it's important that the bylaws be consistent across that, and also that they be reflective of what the existing governance structure is by statute. So that's the project we've undertaken, and this is the second step. The board adopted the first step in December when it adopted the MTA revised bylaws. This is the step that updates each of the agency bylaws to do the same.
So we need a vote on this, right?
Yes, we need a recommendation to the board on this.
In favor? Okay. I think Lamont's the second item. Is that right?
That is correct.
Okay.
Status on the self-assessments. As of now, we have received 13 of the 22 assessment surveys that we sent out for approximately 59%. We are compiling the results that we did get in, but obviously the higher the percentage of participation, the more representative the results are. So we will be reaching out to those of you who have not handed in your survey to try to get you to hand them in. Okay? And I brought some with me just in case anybody would like one. Yes, I could. I could definitely let you know. Absolutely. And that is the status. If there are any questions?
Okay. It was a long time ago.
Yes, I initially sent it out in January.
You must have complied, I'm sure. Okay. Jim, you have the presentation on recent developments in corporate governance. Review of the Public Authority Reform Act of 2009.
Yes. One of the missions of the committee by statute is to review trends in corporate governance and such matters. And so we thought it might be timely, given the passage in December of additional public authority reform legislation, to do a summary of the major provisions of that. In your books, we've enclosed a short 8-page or so document that was prepared by the Authority Budget Office that provides somewhat more detail of the provisions. You have a handout that I can go through in less detail given the time than otherwise, and provide a high-level summary of some of the major provisions that were contained in the Public Authorities Reform Act, which was passed in December of 2009 and became effective in April of this year.
But we did this already. We did this in an early meeting.
No, we did, I think, a summary of the May 2009 legislation. I don't think we walked through this.
Good.
I did distribute a memorandum to the board members, I think, that provided a summary back in December or January. The topics that I want to quickly go through, there's the creation, or rather the enhancement of the powers of the ABO, the Authority Budget Office. There's some specific board governance provisions that were adopted. There's some additional reporting requirements, and there's controller review of contracts and changes in property disposition requirements. As to the ABO, or Authority Budget Office,
Bless you.
that was created, bless you, in 2005. The changes that this legislation made include enhancing its independence by giving it director who has a fixed term appointed by the governor and removable only for cause. So that was a change that has been made. The current, I think, interim director, because I don't know that he's been confirmed yet, is David Cadera, who was formerly the State Budget Office and who had been running the Authority Budget Office prior to the legislation. In this office, not a board, it's an office, and it has a staff of only about 7, which has caused the office itself to have some concerns because its staffing was to have been enhanced, but with budgetary troubles of the state, that has not occurred.
This office could recommend the suspension or dismissal of any of this?
To the appointing officer.
For cause or for any reason?
No, a board member can only be removed by statute for cause. The enhanced, member...
Did they revise qualifications for board member? What are the qualifications for board member?
Well, the May statute of last year, the May 2009 statute that's specific to the MTA, added some very broad language that talked about backgrounds in finance, engineering, accounting, listed like 10 or 15 fields or other matters relevant to the matters that come before the authority. So I don't think, looking at that provision, that there are any issues there. Removal grounds are as before. What the statute does, and this is skipping ahead a little bit, if you go to the next page, is it adopted a very specific fiduciary duty provision. Before, I think most of us felt that at common law, fiduciary duties already existed for board members. The proponents of the legislation have wanted for some time to essentially codify in a statute what those duties are in a broad way as to fiduciary duties. So that's what you see on the second page, is what they put into the statute was that board members must perform their duties in good faith with reasonable diligence and care and skill, and finally exercise independent judgment in doing so. And they added some specific language that refers to the relationship between exercising those functions in accordance with that standard and the views and policies of elected officials. And the statute specifically acknowledges that board members may take into consideration the views and policies of elected officials or bodies, but that ultimately board members are to apply independent judgment. So that was the fiduciary duty codification that the legislature adopted and the governor signed into law. You'll recall having signed acknowledgement forms back, I think, in March or April, which was also a requirement that the reforms in December 2009 implemented. As to board committees, there were some, from an MTA standpoint, very minor changes that probably had larger effects on other public authorities. MTA for some time has had an audit committee, a governance committee, and finance committee, had all those things preceding any legislation. The new law provisions mandate that a governance committee look at ethical and conflict of interest issues, perform board self-evaluations, recommend bylaws. Those are all things that are already in the charter of our governance committee, so that doesn't really affect us. The finance committee, mandated in the statute, mentions that they should be involved in considering bond issuances and making recommendations regarding those. That's something we already do as well. So those changes really reflect things that the MTA was already doing. Other public authorities may not have had those kinds of committees and been doing that. But I think for us, those didn't reflect any need for major changes. On the next page, the law adopted additional annual reporting requirements. Now, some of these were already familiar to MTA agencies because the May legislation that had been passed earlier, which is MTA specific, had already imposed a bunch of requirements, including this mission statement and measurement report requirement. So we are already doing that. The December legislation took a number of those reporting requirements that had previously been imposed on the MTA and said all public authorities are going to do these kinds of things, although there are some specific requirements that weren't contained in the May legislation that we now have to do. Those include requirements that we list biographical information for board members and certain officers of the agencies when we file our annual report, provide the board self-evaluation to the ABO, and make some other reports that we previously didn't do. On the whole, most of these requirements we were already doing because we were already doing a 4-year financial plan. We were already considering our operating financial risk and our financial reports and our disclosure instruments. So a lot of it's just a question of taking the same information, recompiling it into a new form for the ABO. The next page talks about something that is very new, which is the controller approval of contract provision in the new law. And let me take a minute on that. What this law does is say that the controller may, it doesn't require the controller to, but it says the controller may exercise review and approval authority over certain contracts. What contracts? According to the legislation, the contracts need to be contracts in excess of $1 million in value. And once you take those contracts, it's a subset of those. They have to then either be contracts that are not competitively awarded, so that's single source, sole source, or otherwise non-competitively awarded, or contracts for which the state has appropriated monies for such contractual expenditure. So this is a subset of our contracts over $1 million that fall into one or the other of those categories. Now, that doesn't mean under the statute that the controller will review all of such contracts, but what the legislation says is the controller may do that. The legislation says the controller has to then figure out which ones it wants to review and approve, and the controller hasn't yet told us all, the public authorities, which ones those will be. They are working on promulgating regulations and working on assessing how they're going to exercise this authority, but we have not yet had a contract or category of contracts that the controller said, yes, we're going to exercise review authority with respect to those. But it's likely to come down the road.
Do we have any requirement to fund their review of us?
Not specific to this provision, although I believe that there's some other provisions that previously existed that may provide funding for the controller's office from the public authorities in general. I don't think there's any specific funding in this provision for the controller. But let me check on that. I know there isn't any specific funding in this provision. I believe that there is some percentage that public authorities gets taken from something, from appropriations made to us and goes to the controller's office, but we can check on that.
Just curious at how, aside from looking at it, how much of our money can they spend?
When you imagine the number of public authorities and the number of contracts involved, to exercise this power in a very broad way would require substantial resources. The controller does this already with respect to state agencies.
Absolutely right, though, but we should know what the limitation is in terms of expenditures. I mean, so many people are investigating this every day in one form or another, but to use our own funds to be investigated seems to me ought to be limited.
We'll take a look at what our existing funding of the controller is, if you make a note of that.
Is that where our bond fees go?
Well, we do. We know that we pay bond fees to the state. I don't know that they go to the controller. When the controller does exercise, if and when the controller exercises review, there's a 90-day process, up to 90 days, for them to either approve, disapprove, or it's deemed approved. The controller has indicated that their experience in doing state contracts is they're frequently a lot faster than that, but of course we have...
We know oversight can be very quick or oversight can be forever. So.
Exactly. The final provision that I wanted to call to your attention, given the shortness of time, is on the next page, the property disposition for less than fair market value provision. You may recall that the prior law had contained a broad provision that permitted below market dispositions that would, there was some language that said would further public health, safety, or welfare, or an economic development interest of the state or a political subdivision of the state. That language was removed when they passed the Public Authority Reform Act of 2009, and instead there was language put in saying you can't do below fair market value dispositions unless you're doing it to another government or public entity, and not just for them to flip it, for them to, they have to retain their interest in the property, or the disposal is within the purposes, mission, or governing statute of the public authority. Well, that's very broad language, and it doesn't seem very limiting. That hasn't been defined by the Authority Budget Office or any court yet. So I think that provides a good basis for much of what we do with property. We use property for transportation purposes. We also use property revenues to support our capital program and to support other operating expenses. So I think our mission is broad. finally, if it doesn't fit into either of those two categories, then the Senate and the Assembly and the governor, having this legislation reserved for themselves essentially a veto power over a below fair market value disposition. They have to be given notice of it, and then they have a time period in which to say no. Not as a collective, but any one of those bodies, either the Senate or the Assembly or the governor through a certification. So under this provision, there are some additional restrictions there. There are also, for proper fair market value dispositions that are below fair market value, but which we're allowed to do under these exceptions, the board, they have to come before the board, and the board has to approve them and find that there was no reasonable alternative to the proposed below fair market value transaction. But there were good reasons for it, and the board approved it. There are other things in the bill, but given the shortness of time, let me refer you to the handout that we gave you. If you have any more particularized questions, I'd be glad to address them here or on another occasion. Thank you.
Any other questions? Okay. Lamont, we have the travel policy.
Okay. As you know, in the work plan, we are required to do I'll call a compliance review for compliance with Public Authorities Law Section 2824, which requires that the board adopts certain written policies, and a summation of our findings is contained on the last page of your handout. The only recommendation that we have right now is that we adopt certain revisions to our travel policy, which has not been approved by this board since 2006. Most of the changes, I think, are typographical in nature. The only substantive revision that we're making or recommending is for the chairman, upon recommendation of the controller, to have the authority to adjust the per diem meal allowance and the mileage reimbursement rate without having to bring the entire policy back to the board every time those change.
Recommendation of the MTA controller.
MTA controller, that's correct. Sorry.
Thank you.
Sorry.
No, that's fine. I just want to make sure we weren't going back to the state controller for that.
No.
For that guidance.
Need a motion?
Please.
Yes.
Do I have a second?
Second.
In favor? We done. Then can I ask if there's any other business? Hearing none, may I ask for a motion to adjourn? Thank you. And I will see you on Wednesday.